So I'm going to be talking about guidelines that the DMLA have developed for copyright enforcement services. Before we get into the slides, a little bit of background. The DMLA Legal Committee decided that it would be helpful to create some guidelines for copyright enforcement services acting on behalf of rights holders who are trying to protect and enforce copyright in their work. A thread you'll notice throughout this presentation is that this is a bit of a tricky tightrope to walk. We have members who work with copyright enforcement services, but we also have members who have been forwarded notices that their angry clients have received. And of course, we also represent copyright enforcement services themselves. So we wanted to create something that would make everyone equally unhappy. No, we wanted to create some assurances that to all of these stakeholders that copyright enforcement services are doing their job the right way. And in particular, we want these guidelines to be helpful to copyright enforcement services, really a set of reference points that they can use to stay on the right path, and possibly some points that they may not have considered in doing what they do. Next slide, Paul. Okay, so copyright enforcement is a hot topic in the legal world and not just in our community. Increasing numbers of lawsuits being filed, copyright troll allegations with court sanctions for inappropriate conduct, making regular headlines. Also in the background, we have the Small Claims Enforcement Act, which if passed, copyright enforcement services could play a vital role in that process. And in terms of hot off the presses news, I think it was last week, a copyright enforcement service not a member of DMLA was sued in the Central District of California for abusing DMCA Section 512, a topic we'll hear about in a separate presentation, through sending automated notices to social media platforms to get the account shut down essentially, and force the alleged infringer to settle the claim to get their account reactivated. So these are really important big topics in law and not just with us. And so again, the balancing act tightrope reference, look, we're all about copyright at the DMLA and working to ensure that our members' rights and content are protected by robust copyright laws. We want our members and all copyright owners to be able to protect and enforce the copyright in their work. But we don't want our industry to be tarnished with a broad brushstroke of engaging in unethical conduct. We may be called trolls, but it doesn't mean we have to act like it. Next slide. So this really hits home the same points about our mandate in creating these guidelines, so I'm not going to spend a whole bunch of time on this. One thing I want to mention, though, is the Wild West copyright enforcement point. Some of you might say, well, what's wrong with us being aggressive and assertive about our rights? Our content is stolen left, right, and center on the internet. Why should we be the nice guys and get pushed around here? We're not saying that you can't be tough or that you have to cave in to infringers' demands. But to realize, and I think all of us do, that there are potentially negative consequences for all of our members if rights owners and the services acting on their behalf are, for example, making arbitrarily high demands for payments, being non-responsive or non-cooperative with claim recipients who want more information about a claim, or just being overall sloppy about due diligence before sending out a claim. And keep in mind, these are guidelines, so they aren't rules or bylaws. They're recommendations to help ensure that copyright enforcement services and copyright enforcement is done properly. Next slide. Next slide, Paul. Thanks. Okay, so how did this happen? As someone with firsthand experience, both as in-house counsel and in private practice in handling copyright infringement claims and working directly with copyright enforcement services, I was tasked with creating the first draft of these guidelines. The legal committee reviewed my initial draft, and we went through a round of revisions before providing it to the DMLA board for review. And this included review by the copyright enforcement services who belong to DMLA so they could provide their valuable input. And we incorporated many of the changes that were proposed to us by the copyright enforcement services, including practical concerns about communicating with infringers by electronic means and not automatically providing all information requested by infringers if it was essentially done as a delay tactic. Look, the last thing we wanted were to create ivory tower guidelines that did not take practical considerations for the services themselves into account. Next slide. Okay, so I'm going to read out the mission statement itself. The service, this is what we have at the top of the guidelines, and it's the service acts in good faith with rights owners, clients, and claim recipients in a professional and courteous manner that protects and respects the value of copyright while ensuring that claim recipients are treated fairly. And again, our goal was to strike this balance of having vigorous but fair copyright enforcement. We divided the guidelines into the following sections: pre-claim due diligence, communications, licenses, website, client relations, and settlements. Next slide. Okay, so I'm going to talk a little bit about each section that we have for the guidelines, and starting off with pre-claim due diligence. And this is really the basics of ensuring that it's a valid claim so that the content actually matches with what the recipient is using on their website, that it's not it's a commercial use. And I use that term broadly, meaning that it's not grandma's Facebook page that you're pursuing. The client has standing to bring the claim, so they're either the rights owner or an exclusive licensee for the content. No license exists with the user of the content. Work is done to ensure that the contact information for the recipient is accurate. And the baseline fee is calculated based on standard fees for the same use, and it's not determined arbitrarily. And finally, that the licensing model itself is taken into account. So for example, is it rights managed or royalty free? And with royalty free, of course, we have the particular challenges of identifying the end user. Communications, so including the name of the contact point at the service, along with complete contact information. So email, physical address, phone number, an indication that the service is not a law firm and that the person is not a lawyer, if they are indeed not a lawyer. Using plain language in communications without legalese or jargon. Setting out the basis of the claim with proof of use, so it's easy for the recipient to see, who's probably not familiar with copyright, what the claim is about exactly. They can identify the content itself, where it is on their website, and what is being asked of them in an easy way. No, avoiding hyperbolic or unnecessarily threatening language. Of course, communicating if the recipient requests that the service communicate with a lawyer, that is done. And reasonable proof is provided upon request. So for example, the underlying agreement, if it's an agency, between the agency and the creator of the work, copyright registration, if the work is registered, and overall being transparent about the status of the claim. So licenses, that refers to providing an opportunity to the recipient to provide a valid license if indeed they have one. Of course, confirming that the matter is closed if the recipient is able to provide a license. Informing the client if there is a license and updating the service's own internal databases to ensure that the same thing doesn't happen again. And overall being cooperative with non-client licensing agencies as well, who may get involved in claims if they're asked to provide confirmation of a license that was in fact granted to the recipient, and not making onerous demands upon that agency. So a website, well, having a website is a good idea, and including accurate and current contact information on the website, along with some form of FAQ section or the equivalent, so people can understand who they are, what they're doing, and what this is about in broad terms. Client relations, that refers to making timely payments to the client itself. Reviewing the client contributor agreement to ensure that the client, in fact, does have the actual right to assert this claim. And overall, again, acting in a manner that will reflect well on the client's brand. And finally, settlement, taking the financial situation and status of the user into account. For example, if it's a not-for-profit agency or a charity, having a certain degree of flexibility with settlements. The standard settlement agreement that they use is easy to understand and includes a release for past use, and providing different payment options to recipients. And a final point, these are not guidelines for lawyers. We're not in a position to do that, but the service should take steps to ensure that the lawyers they're working with are experienced copyright lawyers who act in an ethical manner in handling claims, that they're responsive and they try to resolve claims in good faith with infringers before escalating to litigation. And then a final point, you're probably wondering, well, where are these guidelines? We only recently had them approved and finalized, and the DMLA IT team have been somewhat busy lately. So we haven't gotten them up on the website as of yet, but they will be up soon. And I would imagine under the copyright education banner or somewhere where everyone can find them on our website. But feel free to reach out to me or anyone on the legal committee if you'd like to see a copy of these guidelines now. Thank you.